Halo guys, Assalamualaikum warahmatullahi wabarakatuh. Hello guys, good afternoon, good morning, good night, or anything that whenever you watch this video. So guys, welcome to my video. Hope you enjoy it. Don't judging, don't get boring, don't get mad because it's my first time. I know it's a little bit cringe, but please appreciate my video. So please enjoy this video with your best position and the best time. Hello guys, how are you? I know it's going to be hard times and the tough moment that we have been through about this pandemic for it's a little bit 2 years. I know it's hard because we cannot see our friends, our family, and our boyfriend or girlfriend or anything else, and we cannot go to the school and we cannot go to the college. We cannot go to the work or anything else because the rules make we have to stay at home and quarantine ourselves, and we have to stay healthy. But the point is, I'm great, and I hope the viewers is great too, because this video is going to give your insight for some perspective about the materials. But guys, it's going to be better to me and it's going to be polite to me because I'm going to tell you and I'm going to discuss some topic, interesting topic. But I guess, like I said before, it's going to be better and it's going to be polite to me to introduction myself first and explain who am I or anything else. So guys, my name is Laila Putri Aulia. You can spell it by Ayla. And if you hard to read them, I will write on the screen so you can see on the screen. That is my name. And usually my family called me as Kakak, and my friend usually call me as Laila because I'm a free person. So it's up to you guys to call me anything that you want or anything you like about me. Just as long as you don't, you know, talking bad to me or call any bad thing to me, I appreciate it. So call me just, but I prefer you call me as Layla. It's going to be easy to me to explain some topics after this. And because this video is going to be my test video for the mid examination, it's going to be better to me to tell my ID number. My ID number is 811142009 and 3. If you're confused about my pronunciation or I just too fast or anything else, I will write on the screen. As you can see on this video, there is my ID number. I know it's not important things, but I just want to tell you about my ID number because it's my test video for the mid examination. So guys, I have tell my name and I have tell my ID number. The next is I'm going to tell you about my college. I study at Universitas Negeri Semarang, or usually or commonly people say it UNES, which literally at Semarang City in Indonesia. So guys, I'm study at UNES and I'm the student of Faculty of Law. Guys, I have introduction myself and I have tell you about my condition, my name, or anything else. So guys, this is going to be my the first video from the test examination. So I want to tell you and describe my intention, why I made this video, or for what this video is going to be, or anything else. I know this video is going to be your some sources if you want to learn about this topic right now, but I have another intention and I have another purpose to make this video. So guys, as you know, this video is going to be my mid examination, so this is going to be fulfill my task in the some subject. As you know guys, I'm the student of Faculty of Law. Of course this video is going to be fulfill my task in the law faculty. but the subject is international law because I'm student of the faculty of law. Of course, I have learned about international law and anything else. So this is going to be my international law video. But I will bring some interesting topic that we're going to be discussed and we're going to be talking, and I want to know about your opinion about this topic, and I want to share my opinion and what I have learned before for some it's about 8 weeks about the international law from my lecture, that is Mr. Ridwan. So and I want to say to Mr. Ridwan, this is my video for fulfill my test examination. I hope that I'm going to be got some A score. It's a little bit dream, but I hope that Mr. Ridwan will appreciate me and respect my effort to make this video. Okay, because this video is going to be talking about international law, of course that I have promised you before about the interesting topic. That is, you can see on the screen about the title. The title is Relation Between International Law and the National Law. As you know, in the world we have some many part of law and the kind of law, but right now I have chances to explain about international law and the national law. Specifically, I'm going to talking about the relation between the two bodies of it, and it's a little bit better to me. Before I explain about the main topic, there is a relation between international law and the international law. It's going to be better to me to explain what is international law and what is national law, because I bet for you guys that not all of you has been understood about the what is international law and national law. So I will going to explain about what is international law and what is national law, about what kind of sources or what is the subject and anything else about them. And if I have chance in the middle of this video, I have and I want to explain some cases in the world about the between relation between international law and the national law. So we're going to move to the international law. Alright guys, we'll move to the next session, which is the session about international law. So in this session, I will talking about international law, what is the definition and what is the opinion from all of the people in the world. Not all of the people actually, just like, you know. And I'm going to explain about the subject and the sources. So we're going to start from the definition. So one of the authors, which is the writer from the early international law in the beginning, there is Emeritus de Vattel, in the 1714 until the 1767 has been stated that the law of nation is the science which teaches us the right subsisting between nations or states and the obligation correspondent to those rights. Meanwhile, Hackworth said that international law is a set of rules that regulate relation between countries. Alright, after Emeritus de Vattel, one of the author in the beginning of international law, has been declared about his opinion about the international law, and the Hackworth said about the definition of international law too. We're going to move to the Brierley. Brierley defined the laws of the nation or international law as the supreme of the rules and ajas action that are binding to civilized countries in their relationship between one and another, like that. So really, Hackworth and Emeritus de Vattel has been decided, and uh, declare about his thoughts and declare about his opinion about the definition of international law. So all of you guys can, you know, take some definition which you feel most relatable with you. And I'm going to explain another definition too. So we have to be put some many definition so that we will going to be make some conclusion about the definition. So before that, I have explained about what is international law from the other opinion and from the other person. So right now, I'm going to describe what my opinion about international law. International law, you can assume that or you can interpret it as the law which is regulated the activities from the entities in the international scope. And this is what make international law different from the other law and from the national law or another law, because the national law which only regulated national entities, but international law was limited to regulating behavior and relation between the other countries. And time makes some progress in the international law and will continue to keep up with the times. International law right now regulates some regulates some relationship and patterns of behavior regulated by international law are getting wider from before, because before international law just regulates some activities of the entities in the international scope, just like regulated some behavior and the relation between the other country. Right now it's more wider and getting wider because the time make international law right now to progress. So guys, after I explain about describe and the definition of international law, maybe right now we also think that international law, it seems like a real law and seems like a part of law. But according to John Austin, which he said by quote by Schwarzenberger, that he said international law is not the real law, and international law just deserves to be categorized as a positive morality. Why? Why he said that? Because John Austin think that and John Austin said that international law doesn't have anybody of legislative body and doesn't have sanction which can be forced to the other countries like that. So he said then he have a perspective that international law is not the real law or the part of law, it's just like a positive morality, just like that. But we also know I'm the person who believe with the perspective who said that international law is a real law. I'm perspective and me personality more believing to their opinion between John Austin, because as we know that international law is not only positive morality they doesn't because they doesn't have a legislative body, but international law as we know have some Interpol, International Police, and have a United Nations, and we know that international law have their own rules, own law, which some countries regulated in their country too, and something like that. So I'm the personality and me personality more support the opinion who said that international law is the part of law and the real law. So after I explain about what is international law, it seems more funny and it seems more interesting if I explain about the nation law. So we move to the nation law. Alright guys, I have explained about what is and the definition about international law. So right now I'm going to explain what is national law, because we're going to talking about some relation between international law and national law. It's more better if I explain about national law too. So I have read some book, not book really, it's like an article who said that national law is a legal entity that is built to achieve the goals of the state, to achieve the goals or purpose or intention of the state, which is sourced from the philosophy and constitution of the states. As we know, we have a constitution in 1945, and in both of which are contained the goals, foundation, and ideals of the Indonesian state law. So that is the definition about national law. It's like a little bit seems like international law, but in national law it's more specifically talking about and have some goals, have some purpose to the state. So international law is just like one law which regulated in many countries and implemented in many countries. But national law, it's different from the other country. Like the example, national law in Indonesia and national law in the Malaysia, it's really different, because we have we don't have a same perspective, we don't have the same purpose or goals. So in many countries it will be different, the national law too. So like that. Alright guys, after I explain what is international law, what is national law, I almost forgot to tell you guys that international law have some institution too. Example is United Nations. As we know, in Indonesia it's like a PBB, Perserikatan Bangsa-Bangsa, and then after that they have ICJ, International Court Justice. It seems like similar with the court which in the Indonesia too, in the court of the national law, but the difference is in they have in the international scope, it's more wider and more specifically problem to discuss and to justice in to judging in the justice and the court justice, something like that. After I explain what is international law, what is national law, right now I'm going to tell you about some sources in the international law. Like I said before, that I'm not agree with John Austin, which he said about international law is not real law or is not the part of law. But the fact, as we know too, international law have some sources. Right now I'm going to tell you what is sources in the international law. As we know, in the national law we have some constitution 1945, and then after that we have some keputusan MPR, and then the others, so many sources in the national law. But international law have some too. They have 5 sources. The first is treaties. Treaties is from the other country, which after that implemented in the international law. Some country make some treaties between them, and they gonna be to sources in the international law. And then after treaties we have some customary international law, which customary is implemented by their nation, by their country, but implemented in the international law. So the customary international law we take in the or we take from the many countries in the world, especially within the international law or in the United Nations. And then after that we have some customary international law. We have principal international law, which is taken by the country in the United Nations. It seems like customary international law, but it's the difference is the principle and the customary or the convention. And then we have 3, and this is the main sources, but the 2 of them is like some people said that we have 2 another sources in the international law. That is, first is jurisprudence, jurisprudence from the old or from the some jurisprudence in the past. And then after jurisprudence, we have some doctrine from the expert ex, expert from the international law, or expert from the law in the world. So it's free from the other country, which one who, yep, it's free from the other country, just as long as you were a member from the United Nations. So we have 5 sources, which the 3 is main sources and the 2 just like, just from the other explanation, from the other perspective, from the other opinion, from the other people too. So I just want to share that we have 3 sources, but I'm personality and me personality more trustable with the 5 sources. So after that, we have discussed about what is international law, what is national law, and the institution too, and we're talking about the sources. I know that even though I don't explain about what is treaties, what is, because this is not, because this video is not going to talking about them, so I will skip them and continue to the main topic, which is relation between international law and national law. So we're going to move on. Hello guys, we're going to move to the main topic, which is going to be the most interesting topic we will going to discuss about that. And if we talk about international law and the national law, then we will lead to the several theories, the famous and the most frequently discussed theories, which discuss the relationship between international law and the national law, or anything else about them, are the theory of monism and dualism theory, which most famous, most frequently, and there are so many experts to discuss about these theories. So we're going to move to the first theory, which monism theories, or theory of monism. So we're going to move. So right now we're going to talking about the first theory, which I have said before, about theory of monism or monism theories. So we're going to discuss about what is monism theory and what is the monism theory state about international law and the national law. So monism theory says that first, international law and the national law are irrelated, or you can say that this of international law and the national law have some connecting, or have some connected between them. Yep, something like that. So we're going to talk about relation, and then international law and the national law have some relation or connecting. It's proof that international law and the national law have some relation that we're going to discuss later. And the second, monism theory says that international law is continuation of a national law for foreign affairs. So, international law is some another level or some next level from national law, which specifically for foreign affairs, discuss about foreign and the other country, not only by their country but in all of the country in the world, something like that. And in the monism theory, there are experts which famous because he said and he stated about his opinion and point of view of monism theory. There is Hans Kelsen, which I'm going to put his picture in this video so you can know who is Hans Kelsen and what he talking about. So Hans Kelsen said that a national law is inferior to international law. Yep. Hans Kelsen said that national law is inferior to international law, and therefore national law must be and it have to be subject to and in accordance with international law. And national law and international law are basically have some derived from one general legal system. So you can say that international law and national law have some same sources, or because from one general legal system, something like that, that Hans Kelsen stated about. And then national law, according Hans Kelsen also strongly and really strongly opposes the difference between international law and the national law, because according to him that international law and the national law is this have the same position and have the same sources and have the same, like similarity, because according to him there is no difference between international law or national law. It's so Hans Kelsen stated about national law and the international law are same and similar, but the difference just like international law is implemented in all of the country who believe and who implemented international law in their country, but national law just implemented in one country, and so therefore national law is different from another national law from the other countries, but international law just one and implemented in all of the countries who believe them. So after that I'm going to talking about some point of view. There are two point of view from the monism theories, so I'm going to talking about them. So we're going to move. Alright guys, like I said before about theory of monism, I want to talking about theory of monism because the theory of monism divided into views, which these views state to different opinion, completely and definitely different opinion. Although this theory is same in the under theory of monism. This theory is the first theory of monism who supporting or who priorities of international law, and the second is theory of monism who supporting or who priorities of national law. So the difference is priorities international law and the other one is supporting national law. So we're going to talking about the first theory is theory of monism who supporting and who priorities international law. This theory states that international law comes from national law, so that and therefore national law must be subject to international law, or you can say that national law must be obeyed to the international law. And this material is knowing by primate principle or Ajax primate. What is Ajax primate or what is primate principle? Primate principle is the principle is that when every country and the national law must comply with the international law if the country recognized to international law, or is the point is I'm going to say that in about in my style, every country or every national law must be obeyed and must be subject to international law if the underline if that country or if that national law is believing that international law is exists and implemented in their country, so that the national law must be subject and obey if they believe. If they not believe it, the international law not be subject, or the national law not be subject of international law. Okay, then we're going to the next step. This theory states that international law has a higher position than national law. If we're talking about the higher and the position, which is the most important question before we're talking about is which one have the higher position or the lower or anything else. This theory said that international law have a higher position between national law, or you can say that national law is under or below international law. That is from the theory of monism who's supporting or who priorities of international law. Then we're going to talking about the theory of monism who's supporting or who priorities of national law. Okay, this theory said that international law or national law. So you can say that international law or national law. And the second is international law is only a continuation of national law for foreign affairs or foreign business. So it's like I said before, that international is just like next step or next level from the national law. And why this theory said that like that? Because it's supporting by some argument who said that the law that exists or is actually exists or actually applicable in the community or in the country and can be enforced is just national law. International law can be enforced in some country on is not more applicable than national law. So this theory said the real law or the applicable law or the law can enforce just national law. The international law cannot. And then international law on the will of its country to comply with it. International law on will of its country to comply it. So that is of monism theory. It's more interesting, right? So we're going to move to the next theory, which is dualism theory. So we're going to move on. Alright, right now we're going to talking about the second famous theory. It's completely different from the first theory that I said or I discussed, that is monism theory. Right now we're going to talking about the dualism theory the theory of dualism. What is theory of dualism or what this theory states about? So the most famous view expressed by the theory of dualism is that national law and the international law is completely, definitely, and absolutely different. I'm going to repeat it. International law and the national law is different. It's very and completely different from the monism theory or theory of monism that said international law and the national law is same or similarity. But in this theory, it states that international law and the national law is different. So in the theory of dualism, there is a view of voluntarism that is the most theories in this theory. There is voluntarism, which said that the problem or existence of the international law, so the problem and the existence of international law lies on the will of the state. So the problem, I'm going to make this clearly, the problem in the international law or the existence of international law lies, or you can say that it's from the will of the state itself. The simple is like that. And the international law and the national law have two separated systems or divided into separated systems. According to Tribal, the difference between international law and the national law is in the subject and the sources. It's completely different from the theory of monism that said that international law and national law have same sources and from the one general system. But right now in the theory of dualism, the international law and national law divided into two separated systems and have different sources and have different subject, which we're going to talking about it later. So according to Anzaliti, the difference between international law and the national law lies on binding basic or the basic of itself. And we're going to talking about subject. Right now we're going to talking about subject in the national law and international law. In the national law, the subject is individuality, is human, is person, anything else. The point is individuality. And in the international law, the subject is country, is completely different. Individuality just one person, but in the country there are so many person, or there are so many people in that are included in that country, so it's obviously different right now. And then the aspect of strength, or the basic binding, it's divided in two. That is, national law is perfectly binding and active. So national law is have a strength and active, and binding basis is active. But in international law, it's imperfect, or it's not perfect completely. You can say that imperfect, and horizontally regulating or acting more passive. So in the national law, it's perfect and active, but in international, imperfect and more passively. So that the difference between international law and national law. As you can see, that in dualism theory of, or the theory of dualism, international law and the national law have different position and have different sources or anything else who regulating them. But in the monism theories, or the theory monism, the national law is under position from the international law, or you can say that international law have the higher position from the national law. So that my explanation about relation. So we know that in the theory of monism, that international law more higher than in national law, but in the dualism, it's still, you know we have to find out, because there's no explanation about the position or that. So that from my explanation, we're going to move on. Hello guys, with me again Laila Putri Aulia. After I explain about what is international law, what is national law, and what kind of the relationship between them, right now I'm going to tell you and explain some material which have a relation with the previous material of, or the previous topic. Right now I'm going to tell you the role and the function of international law in the application of national law. Right now I'm going to tell you the example too, so I hope you enjoy it. And I have prepared some example that I have read right on my laptop, so I'm going to read for you. The first of role and function of international law in the application of national law is: international law serves to bridge the application of national law of countries. The example is a court decision of a country relating to the object of a case which is partly located in the territory of another country, or evidence in case located in another country. And the second is, international law is required by national law, so that national law legal subject from two or more countries can establish international law relation. The example is an agreement between a state and a private part in a foreign country in conducting international trade relation. And the third, international law is needed by national law. International law is needed by national law because it can function as a means to harmonize various international law of countries regarding a particular issue. The example is countries that join ASEAN, like Indonesia, Singapore, Malaysia, Brunei, Thailand, and then anything else, are realizing that harmonization of national laws from their member countries in certain fields such as regarding legal entities. And last but not least, international law is needed by national law because international law can be input for national law with regard to a problem whose regulation first appears in international or convention. The example is aviation crimes, narcotics, genocide, and many more. So that the role and the function of international law in the application of national law, or the impact of international law in the implementation of national law in some countries. Right now, after that, I'm going to tell you some cases or the example of countries in the world who have a relation between national law and the international. So we're going to move on. Okay, right now we're going to the last part. I'm going to tell you some cases or the example between international law and national law. So as you can see, or as you know, that Indonesia have a national law like Constitution 1945 and anything else. Like there are so many statutes that regulating citizen and regulating some people in Indonesia. But there are international law too who regulating the countries. As you can know, and there are so many countries who join the United Nations. If they have a problem, the example is in North Korea. There are some, a violation of human rights. There are some problems of violation of human rights. As you can see, and what you have to know in the internet, that there are so many blogs who said, or article who said that in that country there are so many and have some urgency about the violation of human rights. So the victim can be solved in their country, in North Korea. So the victim send that the cases to the court or international court justice in the international law to solve them. So that's relation between national law and international. When the country have a problem with that can solve in that country because some government is dictator or anything else, which it's little bit hard to solve in that country, or yeah, there is it. So the victim just can be send the cases to the international law and hope that international court justice would be solve that problem. That's some relation. And you know that USA, United States, have some problems with Palestine or anything else, or Israel with Palestine, and that problems can be sent to the United States and trying to solve. But this is the weakness of the United Nations, because in the United Nations have some 5 country who has a veto rights or hak veto in Indonesia. So the other country cannot fight the decision from the 5 country which have veto, who have a right veto. So it's a little bit hard to solve them, and voting is not it you can say that is useless, because the country who has a veto rights, it's have more power to solve them, or to say that the aspiration or the opinion. So it's a little bit harsh. So that international law sometimes have some stigma or stereotype that not are better than national law, because there are so many countries, like 5 countries who have veto right. it's difficult to solve the problems between country and countries, like war and anything else. It can be solved in the United Nations or international law, you know. Should but in the fact, like Palestine and Israel, the United Nations or international law can solve the war between them. So the point is that international law is strong enough to solve the problem between the countries in the world. It's still a mystery, and we have to find out. So that's all for me. We're going to move on to the last part. Okay, right now we're going to the last part. I'm going to tell you some cases or the example between international law and national law. So as you can see, or as you know, that Indonesia have a national law, like Constitution 1945 and anything else. Like there are so many statutes that regulating citizen and regulating some people in Indonesia. But there are international law too who regulating the countries. As you can know, and there are so many countries who join the United Nations. If they have a problem, the example is in North Korea. There are some, a violation of human rights. There are some problems of violation of human rights. As you can see, and what you have to know in the internet, that there are so many blogs who said, or article who said that in that country there are so many and have some urgency about the violation of human rights. So the victim can be solved in their country, in North Korea. So the victim send that the cases to the court or international court justice in the international law to solve them. So that's relation between national law and international. When the country have a problem with that can solve in that country because some government is dictator or anything else, which it's a little bit hard to solve in that country, or yeah, there is it. So the victim just can be send the cases to the international law and hope that international court justice would be solve that problem. That's some relation. And you know that USA, United States, have some problems with Palestine or anything else, or Israel with Palestine, and that problems can be sent to the United States and trying to solve. But this is the weakness of the United Nations, because in the United Nations have some 5 country who has a veto rights or hak veto in Indonesia. So the other country cannot fight the decision from the 5 country which have veto, who have a right veto. So it's a little bit hard to solve them. And voting is not it you can say that is useless, because the country who has a veto rights, it's have more power to solve them, or to say that the aspiration or the opinion. So it's a little bit harsh. So that international law sometimes have some stigma or stereotype that not are better than national law, because there are so many countries, like 5 countries who have veto right. It's difficult to solve the problems between country and countries, like war and anything else. it can be solved in the United Nations or international law, you know. Should but in the fact, like Palestine and Israel, the United Nations or international law can solve the war between them. So the point is that international law is strong enough to solve the problem between the countries in the world. It's still a mystery, and we have to find out. So that's all for me. We're going to move on to the last part. Alright guys, I have explained some materials about international law. The title is The Relation Between International Law and the National Law, and I have tell you the definition, I have tell you what kind of the relationship and the example, and I said and I tell you about the cases between Palestine and USA, or the Palestine between Israel. But it's time to me to close this video, and I just want to say thank you and sorry, and I want to apologize if my video is too boring or my explanation is not good enough, but I try to be better and I try my best to explain that. So please appreciate it and like this video, and I hope that this video is going to be getting a score from my lecture. That's all from me. Good afternoon, good night, or good morning whenever you see this video. So that's all from me. Thank you for your attention, and I hope you enjoy it. Assalamualaikum warahmatullahi wabarakatuh. Bye bye.